let's begin with you, Kweku. That it's unheard of to have had the court injunct the MP.
Not at all. Not in my view. Indeed, and in fact, my starting point is, if you weigh both sides, I'm talking with the 7 judges, if you synthesize everything that they said, the minority, all that they said was that the same relief that was being sought in the Supreme Court had already crystallized, but they needed to have used a different path to achieve what they wanted in the Supreme Court. So therefore, between the two sides, they all agree that once the High Court had concluded that the MP had lost it and that he was not entitled to have contested in the very first place, he ought to be thrown out of Parliament. The only difference between them is that the majority decided that by reason of the rate that had been put before the Supreme Court, they could rely on it as a basis for granting the interim injunction that they have sought, which interim injunction indeed has the effect of permanently injuncting him. But that is not strange to the law. That is not new to the law. There is authority for the proposition that in an application for an interim injunction, if the facts merit it, the court could grant a final injunction. In other words, a permanent injunction. This is not the first time. So I see, when people say travesty of justice, I don't understand it. And that's my view of the matter. Justice Megache, Justice Doche, they said, no, it's procedure.
Joji, not
Joji, yeah. Agnes Joji.
Yeah.
Her ladyship, Justice Agnes Joji. Their case simply is that it's about procedure, but even then I disagree with them. Because there is also authority for the proposition that, notwithstanding the fact that you've got a judgment, which is a final one, if the means of enforcing it is closed or frustrated, you could bring a fresh action to enforce. There is authority for the proposition under the common law of bringing a fresh action to enforce a judgment, a valid judgment of a court. Except that this is my first time of this fresh action being brought in the Supreme Court.
I think that's the question. The first action you're talking about, should it be in the Supreme Court?
That is so. That is so. So it's about them. I mean, that application itself, insofar as it turns upon an interpretation of the Constitution. Obviously, under our laws, that's the only forum. That is to say, the Supreme Court, where you can call upon the Supreme Court to interpret, in this case, I think it's Article 94(2) of the Constitution. So therefore, even though it is addressed as a constitutional question for the Supreme Court to interpret that section, we have no doubt, I have no doubt in my mind, that that same matter had more or less been ruled upon by the High Court. Call it ingenuity, call it whatever name, but erroneous as good by whatever name you call it. So as long as that matter is the Supreme Court has already determined, and we can tell by reason of the position that the majority are taking, that they would also uphold the main issue that is before the court. I can also state that by reason of the reasoning the minority have given, they will also rule against that writ that has been issued in the Supreme Court as incompetent. So at the end of the day, the matter has been resolved for all of us. There's no travesty of justice insofar as the High Court ruling remains unchallenged. There's no travesty of justice insofar as the Court of Appeal, the matter has been struck.
The minority's view